Ebusian for ne tie for ni di kwan so me pacho me ma obi bia akwaba eba channel so hi daily update TV. Ebusian me pacho high court discharge James Tsatsu Quason. Say charges omode ball no so nyina no. Enim eduayi those charges ni na no enye no kre na so far high court no grant no my friend said discharge and so we discharge no because you see no a free man na ebusia yebeka James Tsatsu Quason case here that was during the 8th parliament and NPP for were poised in making sure say papa will be losing his seat and case ni na by because no almost say or Okradua citizenship Canadian citizen, I mean now or a Canadian citizen and again a Ghanaian citizen of which are now prohibited the laws are Ghana Obibe passes through to become a member of parliament. I just say when you back free so now be nipa say we a Ghanaian citizen and yes we a Ghanaian citizen at the same time being a Canadian citizen. Now in some more debate too call court ball papa we as at the time and papa no or yen papers we bibia now or cover forms are not or failure or passes through the EC system now now you know more a Canadian citizen. So the NPP no force ya your madi be bia so be make sure say papa be lose bet Nyankopon chadom ene ni lawyer your friend Tsikata na it's been a while we've heard from Tsikata na ene Tsikata etuma pie akọ court on a stormy high court aku prove the case ama sisi and this time around no high court net say Tsikata ne nsem no so day ama wama discharge James Tsatsu Quason na ebusia keke omu wie ya omu twa pictures a share videos na spread through elko a omu Tsikata ya fe no papa ya fe ne pa ebusia akasa kakra credit to TV3 Ghana yebeko ne akotie nsem na akasa ne nkyere mu efi on na ya hwe video no so a Tsikata ne client James Tsatsu Quason omu wie ya omu celebrate that victory ne enigye no Nyakopon sha no nya okesi ebedi nkomo eche Nyakopon sha obebre mi dase.
You say when I'm innocent, no matter what you do, they will pronounce as some later date. They were for execution. They were trying to prosecute, but this is a court of law. That's the difference between prosecution and persecution. And I'm very proud that Our Lady Justice Mary. I was going to tell her in the courtroom, but I mean, the rules doesn't allow that. I was going to tell her she's a very decent human being, and more blessings for her. Thanks to God, thanks to all these people behind me, family, friends, my dear sister here, Member of Parliament. I don't know, but my mental state was normal. I'll be honest with you. They will tell you, my sister here will tell you, when you are not wrong, there's nothing you should worry about. No matter where you put the person, they will bounce back. That was my reaction, that I know I'm innocent. I wouldn't do this. I didn't come here to dupe or deceive anybody. I came to help my community here, to help the country, to serve my people and my country. And I made sure I did the right things. But
Lord Edu Asare is our court correspondent, joining us now for a bit more on the story. Lord, good afternoon. Listen, we hear from the Member of Parliament who says that he's always known that he was innocent as far as the charges are concerned. But what was the central argument in the case that led to the discharge and acquittal of him today?
Prosecution held that, two cases actually, they held that in his renewing of the passports, he used false documentation, and then prior to the 2020 parliamentary elections, the prosecution held that he had used dual citizenship, in that he was also a Canadian citizenship. But then, reading out the ruling, or like the judgment, the presiding judge in the matter indicated that there was no evidence of dishonesty on his part because he filed to renounce his Canadian citizenship as far back as December 2019. And so it cannot be the case that as at the time that he was filing the nomination forms in October 2020, he had planned to sort of deceive officials of the Electoral Commission and other officials involved. And so considering all these things, as far as the perjury and then dual citizenship was concerned, they highlighted this in that there are too many inconsistencies regarding what the prosecution submitted, as well as what their witnesses were saying. And so they could not call him to answer to these questions. And they indicated that there was no prima facie established against him. And that's why he was acquitted and discharged him.
I see. How did the court address the accusation of dual citizenship?
So I was explaining that earlier. The court indicated that there was evidence that showed that he had applied to renounce his Canadian citizenship in December 2019. But this was the case that the prosecution was making the case that he had the intention to deceive the officials, as far as the electoral officials, as far as the passport officers. But that wasn't the case. And for something like that to happen, it means that the person should have the intention to do so. They also brought about the case of the form that he had filled at the passport office. There were a lot of inconsistencies from what the prosecution had submitted, and then the evidence that the witnesses who were testifying for the prosecution had indicated. So putting all these together, the court held that it cannot be the case that Judge Quason actually wanted to deceive the public or wanted to be dishonest about the whole thing, and so there was no evidence or prima facie against them to be held accountable or to be held liable for the offenses that he had been charged against. So all the 5 charges which had been proffered against him was discharged, and then he was acquitted.
I see, Lord. Thank you so much for the reporting. Lord Eduasare is our court correspondent.
Reason there has to be representation from the Office of the Attorney General. The Chief Justice was written to asking her to adjourn all of such proceedings, and the Chief Justice, we understand, acceded to that particular request. And so there were a number of cases that the court dealt with even before it dealt with this particular case of interest, and the court adjourned all those matters as well. And so once this particular case was called, a representative from the Attorney General's office, a state attorney who was accompanied by a senior state attorney, actually informed the court that the Attorney General asked that they come and inform the court, because they respect the court, that even though the Chief Justice has granted the request, they nonetheless want to show up and inform the court of the fact that they want the matter to be adjourned because of the symposium that is taking place for all state attorneys.
We understand for the lawyers of the MP led by the former Attorney General Godfred Yeboah-Dame, they have some reservations regarding the conduct of the Office of the Attorney General. Talk to us about these reservations.
I mean, two main issues. The first is he makes the point that this is a symposium that is being organized for state attorneys. And the question he asks is that the Attorney General, the Deputy Attorney General, are not state attorneys, and so why can they not be present here in court? Then he also says that even before, because they can't even show up, they've also sent 2 state attorneys. And so he says that if you can't come, you can send someone to come and represent you in court. Why can't the person also be asked to handle this particular matter? And so those are concerns that he raised. I caught up with Godfred Yeboah-Dame after proceedings, and he spoke to us about these matters and other matters that have come up in relation to this particular case.
I mean, that was quite odd for him to say that senators are very comfortable. All the cases that happen to that, he is not a senator. He cannot come to court. The matter is important than the removal of the Chief Justice. If they come or send the Kesi to court and attend, the Deputy Attorney also not still attending if they come. What makes it more odd is the fact that they send state attorneys, not even 1 but 2 senior state attorneys, to come and inform the court that they are the conference, and so the matter should be done. That is all. Or there's an application for example to injunction pending. So why would anybody proceed? How find a quiet interest and quiet court? It would be the height of any disregard for the rule of law if they proceed in that manner.
So as far as you are concerned, you expect the president to halt the constitution, the council, if all this is pending?
It's not my expectation. It's the expectation of the law. The law expects that such regard for due process be observed. And so it will be actually a confirmation of their disregard for the rule of law. And I think that you should see that belief filed by the Attorney General. I would say that the Lord has a fine way of exposing the hearts and desires of men. The Lord has an interesting way of exposing the hearts, the true desires of men. And indeed, it's been evidence in the affidavit filed by the Attorney General. They did not intend to accord any right of hearing to the Chief Justice until the matter was filed. And they indicated it in the affidavit. So it's quite clear. Okay, I'll leave it at that. The merits determined by the court will argue in court.
Joseph, that's the former Attorney General, but he makes reference to documents filed by the Office of the Attorney General with respect to the affidavit in response to the injunction application. What other details are contained in that before we try and run viewers through that as well?
In fact, the point that is raised in that affidavit is the fact that the Office of the Attorney General takes the view that there is no law or any decided case that compels the President to give a hearing to the Chief Justice in considering a petition seeking a removal. You recall that when the 10-day window was given to the Chief Justice to send their response, there's been lots of conversation surrounding that. And so that is the reference that the Attorney General makes to it. Aside from that, too, those affidavits have attachments that includes correspondence regards the former president. And so they make reference that late last year, you recall when a petition was sent to President Akufo-Addo seeking the removal of the Chief Justice as well, they say that their record shows that he actually wrote and forwarded it to the Council of State 2 days later before he now afforded an opportunity to the Chief Justice to respond to it by way of initial comment. And so they make the point that what President Mahama has simply done is consistent with the practice, but they emphasize that there's no law that requires that such a fair hearing should be extended to the Chief Justice in a determination of whether a prima facie case has been made out.
And finally, what are we expecting happens next, now that this case has been adjourned?
As of now, there's no next date, and so what it means is that the court would have to decide, or a hearing notice would have to be issued by the lawyers in the case for a new date to be fixed. The former Attorney General who represents the Otafo MP had wanted the matter to be dealt with on Monday, but the court said that because the request had been granted by the Chief Justice, it did not want to fix a date, not knowing what may happen subsequently, and so they want to leave it open for now. An interesting point worth indicating is that the Office of the Attorney General, in terms of the state attorney that showed up in court, is actually an individual who served as the personal assistant of Godfrey Yeboah-Dame while he was in office as the Attorney General. In fact, he made reference to it in court and said that it was one of the reasons he didn't want to raise issues with the presence of the state attorneys there, even though the court had been informed that they were supposed to attend the symposium. But nonetheless, he was proceeding to raise it, even though it was his former personal assistant who was represented at the Office of the Attorney General in court. It's that same individual who also swore the affidavit in opposition that has been filed on behalf of the Attorney General. And that is Reginald Odoi, a state attorney.
Interesting development there. Joseph, thank you very much for those details. That's my colleague Joseph Akable, and he sought to touch base with the affidavit with respect to that which has been submitted by the Office of the Attorney General. We're just going to try and run you through those details with respect to that affidavit as submitted by the Office of the Attorney General. But starting off first with the basis for that injunction application by Eko Vincent Tasifo, who was an old Tafo Member of Parliament, whose lawyer is the former Attorney General Godfrey Yeboah-Dame. Quickly, starting off with the basis for that injunction application, and the argument Mr. Asifo makes is that he is advised by his counsel and verily believes same to be true, that should the impugned processes under Article 146 proceed, which is the ongoing process for the removal of the Chief Justice, should it proceed, then they can make a conclusion that instant action is heard. Same will undermine the current or the rule of law and the Constitution, which is the 1992 Constitution, and then the power of the judiciary in discharging its constitutional duty of determining disputes between all persons in Ghana once its jurisdiction is properly invoked. Then he makes a final point with respect to why he's praying the court for that injunction, that irreparable damage and grave injury would be caused to the people of Ghana if the President and the Council of State proceed upon a pursuit of the tainted process, and same is subsequently declared unconstitutional by the Honorable Court. But here's the argument as being made by the Attorney General, some of which my colleague Joseph Akable has been touching on. And the first of which is that he's opposed to the injunction application for starters. Then case. That's a fiction to dismiss the injunction motion and then proceed to deal with the petition filed by, or petition taken to the President by Professor Quason during the tenure of former President Nana Addo Dankwa Akufo-Addo. These are the timelines they quote with respect to that particular petition. That the petition was taken by Professor Quason on the 18th of December. Now, on that same day, the president transmitted the petition to the Council of State. That's a process which happened in December of last year, December 18 to be specific. Then the AG proceeds to add copious details of the fact that the former president forwarded the said petitions to the Chief Justice Gertrude Tokonu 2 clear days later. And it is based on that argument that he says that there is no evidence of consistent practice to support the applicant, in this case, Vincent Tsatsu and one other individual's claim that the petitions must be transmitted to the Chief Justice for response before same is forwarded to the Council of State. And so that's where we are with regards to this case. We can bring you some more details right now.
Abusanfo na tie for meda obi bia se wanya mre no abenya video ni bi nso ahwe Nyankopon hira ye nyina mpacha opine no view ewo comment section section ho ne me beje na yakenkan na me pacha o isi an James Jachi Quason or a free man during the 8th parliament NPP did everything to make sure senka womo be unseating papa we, and not just only unseating papa we. Now me a poise class and come in be call akogina even so me jeli ne kra ombe jeli ne kra nanso omo ye de ombe bia o mantimi na this time around no the high court apia babontin abe discharge papa we omo kire say charges omo de bo papa we nyina no enim charges ni na sa na ye nsem bi no mo keka na those charges ni nyina no court no apia babontin abebu ni nyina egu na utimu se we enije kese pa ma James Jachi Quason ni the NDC fraternity na ebiomu nso no we ne kire say look unya tumi a enforce and try say obeye de obebia we obi be ka say NDC for by enti na omo so my force aye we mu nyina. Remember said judges on those they are the same judges and another time your former president no more. Yes, Chief Justice Tokunu na concerned citizens be and as a Ghanaians be a petition the President of the Republic of Ghana, His Excellency John Dramani Mahama said, "Only feel I no crown and no more court no and so and who update by and say court na I joining sa case no Sini died and I say indefinitely." Obviously, women not to say courts and the judiciary ni ye juma. Said Macan if I will comment a share opine view or comment section on me begging I can go punch on your case. That's a